Hello, my name is Iendia and thank you for joining me today. This presentation is on sexual harassment and hostile work environment. With the passing of the Civil Rights Act of 1964, it became illegal to discriminate against persons on the basis of their race, color, religion, sex, and national origin. Title VII applies to employers with 15 or more employees. So let's begin this presentation by clarifying what sexual harassment and hostile work environment is. There are two forms of sexual harassment: quid pro quo and hostile work environment. Sexual harassment is a form of discrimination. The first type of sexual harassment, quid pro quo, is unwelcome sexual advances, requests for sexual favors, and other verbal and physical conduct of a sexual nature. This constitutes sexual harassment when this conduct explicitly or inexplicitly affects an individual's employment, reasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. Sexual harassment is not just the stereotypical man, the harasser, versus woman, the victim. The harasser can be male or female, as can be the victim. Sexual harassment also does not have to be between members of the opposite sex. The second form of sexual harassment is hostile work environment. So what constitutes a hostile work environment? Let's get real here. When you work around a lot of people, there's always a possibility that someone you work with or work for is going to be unpleasant, juvenile, obnoxious, maybe even mean. I mean, let's face it, people can be jerks. Juvenile behavior, pranks, even an obnoxious attitude do not qualify as a hostile work environment, even though it can make for very lousy working conditions. A hostile work environment refers to the behavior of an individual in a workplace that creates an environment that makes work difficult or uncomfortable for another person. There must be discrimination involved. So even though I broke these definitions into two separate definitions, this presentation is not about one or the other, but rather both of them combined: sexual harassment and hostile work environment. Let's talk about work environments. So what happens if you're a female and say you go into a job in the construction industry, mining industry, any of the traditionally male-dominated job sets? Are you still protected under anti-discrimination laws? In the past, it was argued and generally accepted by the courts, if you willingly entered into a work environment where sexually tinged language, sexually suggestive photos, and even unwanted touching were part of the cultural norm in the workplace, you were expected to accept this behavior. In other words, you knew what to expect when going in. Today, however, this kind of attitude has changed. Many courts now view circumstances from a victim's position. Would a reasonable woman or victim find this type of behavior objectionable? They recognize that sexual harassment in the workplace is a form of sex-based employment discrimination. So at what point does behavior rise to the level of actionable sexual harassment hostile workplace environment? The most common test applied by the courts is the Hinson test. These are elements that were discussed in the case of Hinson v. City of Dundee. To be actionable sexual harassment hostile workplace environment claim, the following elements must be shown. 1. The employee belongs to a protected class. 2. The employee was subject to harassment, unwanted sexual advances, request for sexual favors, or other verbal or physical contact of a sexual nature. 3. The harassment was based on sex. 4. The harassment affected the term, condition, or privilege of employment. That is, the conduct was sufficiently severe or pervasive so as to alter the condition of employment and create an abusive working environment and 5, a basis for inputting liability to the employee. So it should also be noted that in addition to these elements, the plaintiff will need to show that they found the work environment subjectively offensive. A minute ago, I used the term severe or pervasive as far as altering the conditions of employment. So one of the problems in a sexual harassment and hostile workplace environment case is defining these two terms. There's no hard definition for either of these terms. Both of these terms are vague and subjective. My definition of severe and pervasive could be quite different from yours or somebody else's. As a woman, I might find sexual harassment from a supervisor much more severe than that of a coworker or vice versa, depending on the circumstances. A woman's perception of sexual harassment can differ from that of a man's. It's also subjective on how people perceive the term pervasive. These are just a few of the things that make sexual harassment, hostile work environment cases difficult. There's no hard definition of either of these two terms. Another issue that makes these cases difficult is the reasonable person test. Should the reasonable person test be used or the reasonable victim test? In most court cases, the reasonable person test is used. However, in sexual harassment cases, this causes an issue in itself. Throughout several of the papers I read in preparing for this presentation, there seemed to be a conflict as to what standard test should be used. In some cases, it was the reasonable person test. In others, it was the reasonable victim test. And in at least one paper, they seemed to believe that a reasonable woman test should be used. In Ellison v. Brady, the appeals court overturned a lower court's decision on a sexual harassment, hostile work environment case that was based on the reasonable person test. Instead, the appeals court applied a reasonable victims test. With the reasonable victim standard, the person is asked to look at the case from the perspective of the victim. Although this viewpoint did seem to make sense to me when I first saw it, I have to wonder if it doesn't get the victim an unfair advantage in any proceeding. In the paper that I read proposing to use a reasonable woman's view, I found this one troubling. Juries are comprised of men and women. To ask the jury to view a case from the woman's view seems to be discriminating and biased against the defendant, and quite honestly, rather insulting to the jury. It implies that on their own, men would not be able to look at testimony and evidence objectively and come to a reasonable conclusion. Juries are supposed to be impartial and are supposed to look at evidence objectively. Asking them to use a reasonable woman standard or reasonable victim standard seems to shift the balance of how they view a case. Although there have been cases where just one incident was sufficient to establish sexual harassment, hostile work environment, most cases involve multiple incidents that culminate into a hostile work environment. So in the latter case, it's important to keep an accurate record of all incidents. So what about secondhand evidence in a hostile work environment claim? Typically, when most people think about secondhand evidence, hearsay evidence comes to mind. This is testimony that a witness gives that is something he or she was told to by another person that they did not personally witness. But there are several types of secondhand evidence that attorneys fight to have either included or excluded in hostile work environment cases. There are times that a witness may give testimony of things that occurred before the plaintiff was even employed at the company, or things that happened after their employment. There may be testimony about occurrences that happened years prior that are on the outside of the statute of limitations. Another example of secondhand evidence are statements provided by fellow employees that are in the form of an affidavit, but are not signed. Maybe the employee was afraid of retaliation or didn't want their names known. This is just another example of secondhand evidence. All of these can be argued by the attorneys through rules of evidence. The objections don't always work. One thing that benefits the plaintiff's case is when the totality of evidence supports his or her claim. It can be pretty damning and show a pattern of behavior. A good example of this is the Bill Cosby and Harvey Weinstein cases. So what steps should you take if you feel you're being discriminated against? 1. Ask the person to stop. If you're too afraid or intimidated to confront the individual, go to your supervisor or human resources department. 2. Keep a record of everything, emails, comments, phone messages, etc. Documenting incidents of sexual harassment is very important, especially if at some point you want to pursue legal action. 3. If the harassment continues, report it to your supervisor or human resource department. 4. If the harasser tries to retaliate once he's been asked to correct his or her behavior, contact your supervisor or HR department. Retaliation is illegal. 5. If your employer fails to take action, contact the Equal Employment Opportunity Commission. This may also be when you want to contact an attorney. If at some point you find that you're going to have to contact an attorney, it's very important that you've made an effort to inform your supervisor and HR department as to what's been going on and to keep documented records of all incidents. So this concludes my presentation. Thank you for taking the time to watch this. Be safe out there. Bye.